Our next speaker is my partner, Brian Rubin. Brian is the head of our securities enforcement and litigation practice in Washington, D.C. You've already heard a recitation of his background and his accomplishments from the earlier panel from Stacey Hartman. I will now turn the panel over to Brian.
Thank you. Thanks, Larry. I won't make any jokes and I won't make any misrepresentations or lies. We'll be talking about litigating against FINRA and the SEC, and every year we put together a statistical analysis, a study about those actions to see how often the regulators win in terms of the charges that they bring, how often they get the sanctions that they want. And even if you don't litigate against the SEC or FINRA, it's important to know about the statistics if you do work on exams or investigations, because unless you know the possible end result, what would happen at a hearing or trial, you may not be able to handle the investigation well, you might not be able to negotiate successfully. And I put together metaphors or analogies of boxing, because you are fighting against the regulators, you're in their ring. So the question is whether you're Rocky Balboa from Rocky 1 or from Rocky 2 or Rocky 18, or whether you're Evander Holyfield with an ear or without an ear. So there's all kinds of ways of thinking about this, and we'll go through that in this presentation. So initially, fear is the greatest obstacle in learning in any area, but particularly boxing. So if you fear the unknown, if you don't know what happens if you end up litigating, you're not going to negotiate successfully, as I said. You're not going to be able to handle it. So what we'll do today is talk about the process that you would go through a little bit before the hearing, the process in the hearings, in the trials themselves, and then look at some of the statistics. Background. You can see generally there's an upward trend in terms of FINRA's fines, in terms of actions they've brought. Statistically, every year, final concluded litigated cases are only about 2 to 5%, and the same thing at the SEC. So not just like civil litigation, not a lot of the cases end up going to trial, but when they do go to trial, it's important because it gives people different postures, different types of arguments that they can make as they're going through the rest of the process. A little bit of background about the life cycle for FINRA. Where do enforcement actions come from? Well, they come from fact-finding and investigations, which may arise from examinations, they could arise from customer complaints, they could arise from complaints from competitors. There are a number of ways that FINRA could get an interest in an issue and say, hey, we want to investigate this, we want to do some fact-finding. And once they get that in their mind, they send out 8210 requests for documents, for information, they follow it up with testimony, and if they think there are issues, if they think there are violations, you'll then go through a Wells process. So they could shut the case down at the end of the fact-finding, or they can proceed and say, we think there are violations. At that point, the proposed respondents can say, okay, we want to settle, okay, we want to litigate, or they can go through the Wells process and say, we want to convince you that you're wrong and you shouldn't bring an action. After the Wells process, FINRA may decide we still want to go against you. If a complaint is filed, there's a complaint, there's an answer, there's limited motion practice because it's open file discovery, which basically means that you get FINRA's investigative file, and then there's a hearing in front of a hearing panel, and we'll get into that in a little bit more detail, but it's a 3-judge panel. There's the FINRA hearing officer, he's an employee or she's an employee of FINRA, and then there's 2 other members who are part of the industry or were part of the industry previously, and then there's a hearing. On the SEC side, same thing. Complaints come about through the same basic process, and here we're talking about administrative cases. For the most part, when FINRA brings cases against registered entities, against broker-dealers or investment advisors, they have administrative hearings in front of an ALJ. Sometimes they end up going to federal court if it's a big bad Ponzi scheme, big bad fraud, or if they want to send a message and end up wanting to fine a company, say, $900 million. If it's a really big case, they'll go to federal court. But in general, it's administrative, and we've analyzed just the administrative hearings. So the hearing. If I was competent in PowerPoint, I'd have an audio of let's get ready to rumble, but you can use your imagination. So we'll talk about what happens here. At the hearing, you have, we'll do the FINRA side first, as I said. There's a FINRA hearing officer, and he or she is an employee of FINRA. The hearing officer decides all the pretrial motions, and at the hearing itself rules on evidence, and ultimately writes the decision for the hearing panel. There are two other members of the hearing panel, and they don't get involved with the pretrial motions. They just get involved at the hearing, and they vote, and ultimately, as I said, the hearing panel writes the decision. And there was at least one case where the hearing officer dissented, so he wrote the dissent in addition to the majority decision for the hearing panel, which must have been interesting for him. The SEC side, it's standard administrative. It's an ALJ who decides everything, pretrial motions, and then goes through the hearing and writes the decision. To litigate or not to litigate. He who is not courageous enough to take risks accomplishes nothing in life. We're all litigators here, all attorneys. We all take risks of some sort. Usually the risks don't end up putting us in positions like that, but we'll talk about the risks of litigating. A lot of this is like civil litigation. Some of the same issues apply whether to litigate or not to litigate, but there are some different issues when you're dealing with regulatory actions. There are different implications from dealing with the regulators. It could lead to other civil litigation. It could affect your client base if they see that you've litigated or if they see you've had a disciplinary action taken against you. So we'll go through all of these just very quickly. Matter of principle, did nothing wrong. You want to litigate. You want to prove I didn't do it. A lot of times when you're representing individuals, that's the posture. Sometimes firms have that as well. Andrew was talking earlier about the tone at the top. A lot of firms say, we are the cleanest firm around. We didn't do anything wrong, and we're not going to pay a fine or a penalty just to get rid of the case. We want to litigate. We want to take it all the way. A settlement creates a disciplinary history. There's the CRD and broker check by which customers, investors can look up the disciplinary history of member firms and also of reps and brokers. And if you end up settling a case, it's going to be there. So future clients, current clients can read all about it. So a lot of times people want to litigate to prove that they didn't do it so that they won't have a disciplinary history. There's always a possibility of a complete win. You can continue to do business until the case is resolved. We'll talk about that toward the end. These cases take a long time to go through the trial process, the appeals process, just like civil litigation. So one of the issues is sometimes people end up litigating because it allows them to continue working in the business for a year, 2 years, 3 years while this is going on. The disadvantages of litigating, the case drags on. Settlement brings finality. If you're dealing with individuals, they might not want the stress of living through a trial. If you're dealing with a firm, they might not want to dedicate the resources, the time, the energy, the staff in order to get ready for a trial, in order to sit in on a trial, in order to work with the attorneys. If you settle, you can negotiate the language in settlement documents. That's a big advantage to settling. You have some control over what the ultimate settlement document says, and it's a public settlement document. So instead of a document saying this firm did X, you might be able to negotiate on occasion this firm did X, or sometimes this firm did X, or in these limited circumstances. So that's a very important advantage, and firms and the regulators sometimes work for months getting down the nuanced language in the negotiated settlement so that everybody gets something out of it. The findings are binding if you litigate. If you end up settling, historically at any rate, the settlement said you were settling neither admitting nor denying the findings. Most recently, yesterday, we saw that the SEC is actually trying to settle bigger cases, more important cases with admissions. So all of this may change how firms and people analyze and think about these issues. It could cause more firms and individuals to litigate if they can no longer use the neither admit nor deny language. Because the issue is, if you settle with the regulators, then in civil litigation, somebody will come after you and say, look, there's a finding here, you admitted to it, and possibly it could be used as evidence against you, or in some respect, it could be used at a civil trial or hearing. Other disadvantages of litigating, just like in civil litigation, the penalties and costs are unpredictable. Also, sometimes there's a trade-off. Sometimes a firm might be able to convince the regulator, if we settle and if we pay some more money, can you drop the charges against the individual? And sometimes that's said that bluntly, that directly. Sometimes it's said less directly. But it is an advantage when you're talking about settling. And if you litigate, you can't talk about it that way. Okay, so now some statistics. As I said, what we do is we look at all of the litigated cases on the FINRA side. We also look at all the litigated ALJ cases on the SEC side to see what's going on. And what we have here is the 1 year period, and we compare it to sometimes the prior year, and we have some other statistics. But in terms of charges, you see that a case might have multiple charges against a firm or an individual. There might be charges of misrepresentation and unsuitable sales and failure to supervise. So we would look at those three charges as distinct charges. Charges get dismissed 18%. The prior year, it's 14%. Historically, it's been between 10 and 20%. Respondents who obtained a complete dismissal, 14% versus 9% for the prior year. The other thing we look at is the sanctions. For FINRA cases in general, they can try to make you pay a fine, or they can kick you out of the business, a suspension, usually for a limited time period, or it could be a bar, which means you can never come back in again. So what we end up doing is looking to see what kind of sanctions the FINRA staff asks for. So they may say, we think the respondent should be fined $100,000. Then what we look to see is, did they get $100,000? Did they get more or did they get less? So in terms of fines, respondents receive reduced fines 86% of the time, which is probably an aberration. I don't think normally it's that high. The prior year, it's 25% of the time. One issue may be is that FINRA knows they're not going to get what they ask for, so they ask for more, and they end up getting something that they expected to get, and we can't factor that in. Another issue is in terms of suspensions. Respondents got fewer suspensions, reduced suspensions compared to what FINRA asked for 20% of the time. The prior year was 60% of the time. And on rare occasion, you're rolling the dice, respondents got higher sanctions, 10% of the time. Prior year, 29%. And on the SEC side, same kind of slicing and dicing, different numbers. During that year, the SEC was successful 100% of the time, so no charges were dropped at all. Prior year, or the prior time period, which was extended a few years, 25%. Respondents got lower monetary penalties a third of the time. Prior time period, 41%. Got decreased suspensions, 0%. Versus 18%. So for whatever reason, the SEC was very, very successful last year, a lot more successful than they had been in previous years. Appeals. When things are tough, you fight one more round. A number of these cases go on to get to appeals, and let me explain the appellate process. For FINRA cases, you're in front of the hearing panel, which I already talked about. From there, it gets appealed to the National Adjudicatory Council, which is more or less the board members of FINRA. From there, it gets appealed to the SEC, then the Federal Court of Appeals, and then the Supreme Court. On the SEC side, it's in front of an ALJ to start with. It then gets appealed to the full commission. Then it goes to the Federal Court of Appeals and then the Supreme Court, and there is one Supreme Court case that we'll actually talk about. So hearing panel, and then the respondent appeals to the NAC, the National Adjudicatory Council. For these appeals, the respondent can appeal, or the NAC itself can call a case for review. So if they think it's an interesting case or the hearing panel got something wrong, they'll call a case for review regardless of whether there was an appeal by the parties. So if a respondent appeals, the contested violations, the charges are affirmed the vast majority of the time, 96%. The fines are reduced 20% of the time, increased 60% of the time, so that's a crap shot. Suspensions are reduced 29% and increased. So you have to realize that if you're going in front of the NAC, they could increase the sanctions. You have to take that into account. It may not make sense. If there's an independent NAC review where they call the case for review, you see the fines are reduced a third of the time, increased 2/3 of the time, suspensions are reduced 50%. Then, as you narrow it up, NAC appeals to the NAC appeals to the SEC affirms 2/3 of the time, and a third of the time they remanded it back to FINRA to talk about what was going on. And SEC appeals to the Court of Appeals. What they ended up doing was remanding it because there was some confusion about the sanctions and what was being applied and how it was being applied. On the SEC side, during the time period we were looking at, there were no commission opinions where a case was appealed from an ALJ to the full commission. During the prior time period, the respondents were successful in getting charges dismissed 11% of the time. Sanctions decreased a quarter of the time, increased 31% of the time, nothing in the Court of Appeals. The timing, nice picture again. Getting hit motivates me. A fighter takes a punch, hits back with 3 punches. So the timing is what we talked about before. There's quite a time period between when a complaint is filed with FINRA versus when there's a decision, 15 months. From the hearing panel, OHO, Office of Hearing Officers' decision to the NAC is 19 months. And somebody can keep working, keep doing whatever for most of the cases during that time period. And I'm currently representing a client, and he more or less has said that to me. I don't care what happens at the hearing, I'm going to keep working while this is all going on. And then you see the other time period. Similarly, SEC takes about a year from the order instituting the proceeding, which is the complaint, until the ALJ's initial decision, and 14 months before the SEC would rule on it. Going 12 rounds. So this is taking a case all the way, and as I said, the case went to the Supreme Court, SEC versus Gabelli. This case dealt with a statute of limitations, and there's a 5-year statute of limitations. The SEC argued that there should be a discovery rule. It's fraud, and they said it was hidden from us, therefore the statute of limitations should not start when the bad conduct started. It should start when we discovered the problem. And in common law fraud, that is how it works. However, here, the 5-year statute of limitations is a statute of limitations. It's actually a federal law. So the case went from the Southern District to the Second Circuit to the Supreme Court, and the Supreme Court ultimately ruled that the discovery rule can't be implied in these types of cases because the statute of limitations is based on a federal law, so the SEC could not ultimately bring those charges because the 5-year time period had run out. So this is an example of knowing about the litigation issues, knowing about the legal issues, deciding to take it all the way, and it took several years to go through the court system all the way to the Supreme Court, and the defendant was ultimately successful in what happened. And that's it. So I think overall you see the process, how it works, and you see the statistics. Sometimes you're successful, sometimes less than successful. But as I said, in order to handle an investigation, in order to handle negotiation, you have to know what the possible end games are. And this shows what the possibilities are. Thank you.